very recent decision of the Supreme Court in Sackett versus the United States, and provocatively titled "What's Left of the Clean Water Act" following the Supreme Court's decision. It's hard to exaggerate the importance of this decision. It's, I think, easily the most consequential decision for clean water and wetlands in a generation. It's one of the most consequential environmental decisions ever issued. Unfortunately, it's a very negative decision from the perspective of environmental protection. It brings to close a debate, one of the longest lasting debates in the field of environmental law, that arose soon after enactment of the Clean Water Act in 1972. And in this new decision, the new conservative supermajority of the Supreme Court drastically narrows the jurisdictional scope of the Clean Water Act. As we'll discuss when we get to the impacts of the decision in a few minutes, it will leave more than half of the nation's wetlands now unprotected under federal law. And as you'll hear from Betsy, my colleague, Betsy Nicholas, who is our vice president for program, most of the wetlands that are going to be exposed will not have state protection, meaningful state protection. Even more sweeping, as I discussed, the court's opinion casts into doubt federal protections for as much as 70% of the nation's rivers and streams. Rivers and streams at times intermittent or ephemeral. So let's start at the beginning. I'm going to give a quick overview of how we got here, and I'll try not to bog us down too much in history, but I'm respectful of the fact that at least some of the people on this call probably have done a lot of work on this issue over the years. Congress passed the Clean Water Act in 1972 to restore and maintain the chemical, physical, and biological integrity of the nation's waters, a very broad mandate, and it was a comprehensive reform of federal law involving water pollution, and really represented a recognition that the states had failed to control water pollution in any effective way. There was mounting damage being done from pollution to the nation's waters. So the act prohibits the discharges of pollutants, including fill material, into navigable waters without a permit. And there are two permit programs. One is the NPDES permit program for pollutants discharged from point sources, such as wastewater treatment plants, factories, et cetera. Those permits are called NPDES permits. That's the National Pollutant Discharge Elimination System. And the permits are in states. Most states have assumed the 402 program for these kinds of permits. The second permit program is Section 404 permits for fill discharged into navigable waters. This is administered by the Corps of Engineers, which issues federal permits. Only two states, in fact, have taken the 404 program, have assumed it, unlike the 402 program. And EPA and the Corps share enforcement authority for 404. So the key issue is, what's the scope of the act? The Clean Water Act, Section 502, defines first of all, the act, as I said, prohibits discharges of pollutants into navigable waters without a permit. And then 502 defines navigable waters as the waters of the United States, including the territorial seas. These are terms that are kind of charged with history. Navigable waters has a long history in the 19th century of referring to the waters that are actually subject to navigation for commerce, that are within Congress's commerce power to maintain channels of commerce and that sort of thing. But by defining it as the waters of the United States, Congress appears to have intended to include something more than traditional navigable waters. Those are waters, as I said, that are navigable in fact, or are susceptible to navigation. Indeed, the Senate conference report included the statement that the conferees intend the term navigable waters to be given the broadest possible constitutional interpretation. And that sets the stage for the long debate that has just been resolved, I think with some finality, by the conservative majority of the Supreme Court in this decision. The debate over what does the term navigable waters include? And in particular, does it include wetlands? The Corps of Engineers initially defined the waters of the United States to mean traditionally navigable waters back in 1974, but they quickly expanded that definition to match EPA's broader definition. Its revised definition included waters that were navigable in fact, interstate waters, waters the use or destruction of which could affect interstate commerce, tributaries to those waters, and wetlands adjacent to those waters. The Corps based its inclusion of wetlands on the fact that wetlands perform critical hydrological and ecological functions, including filtering pollutants, storing floodwaters, and providing habitat for fish and wildlife that directly affect the health of the navigable waters. The Corps defined the term adjacent as those wetlands bordering, contiguous to, or neighboring waters of the United States, including wetlands separated from other waters of the United States by man-made dikes or barriers, natural river berms, beach dunes, and the like. We'll hear more about that in a second. That's another critical issue here. So Congress, although it did not use the phrase adjacent wetlands in the initial act in 1972, there was a pretty extensive debate over the scope of the Clean Water Act's jurisdiction, primarily focused on the issue of what wetlands were included and the requirement for property owners to get federal permits to fill wetlands that were covered under the scope of Section 404. Congress debated the scope of the Corps' jurisdiction in 1977 when it amended the act. It ultimately rejected a narrow amendment that would have defined waters as traditional navigable waters. Instead, they enacted a provision. It's one of those provisions you have to puzzle over to make sense of, but they added a provision to Section 404 governing the authority of states to assume the Section 404 program, as the act had earlier allowed states to take over the 402 program for NPDES permits for pollutant discharges. And in that section, they explicitly recognized both that the waters of the United States includes waters beyond traditionally navigable waters, and that they include at least those wetlands adjacent to traditionally navigable waters. And the reason is the phrasing of Section 404 G1, which allows states to assume the 404 program over discharges of dredged or fill material into, quote, the navigable waters, but excludes states from regulating waters that are navigable in fact, including wetlands adjacent thereto. And so the question is, I mean, it seems clear from that formulation that the navigable waters must be broader than navigable in fact, because they give the states to take over the program for navigable waters, but not for waters that are navigable in fact. That's still federal. And then it explicitly uses the phrase, including wetlands adjacent thereto. Now we come to the Supreme Court. This is a long saga in the Supreme Court as well. The first case that came to the Supreme Court is a case called United States versus Riverside Bayview Homes. And in that case, the Supreme Court unanimously upheld the Corps' regulatory authority over wetlands adjacent to navigable waters and their tributaries. The court said the term navigable is of limited import in deciding the scope of federal jurisdiction under the Act. They did not address the question, and they noted they didn't address the question of whether waters that were isolated from other waters of the United States could be subject to federal jurisdiction. They did sort of interchangeably use the words adjacent and abut. And the actual wetlands that was at issue in that case did physically abut a navigable water. That's going to become important as you see the court's revisionist approach to what they said in Riverside Bayview Homes. The next big case was a case called SWANK, commonly called SWANK, Solid Waste Agency of Northern Cook County, where a 5-4 court, now split between liberals and conservatives, holds that the Corps' regulatory jurisdiction doesn't extend to non-navigable, isolated, intrastate waters. The waters in question were gravel pits, miles away from any other waters, that had water that had collected in the bottom of the pits and were supporting vegetation and providing habitat for migratory birds. And the Corps had, by that time, expanded its definition of waters of the United States to include waters that could affect interstate commerce for one example, by providing habitat for migratory birds. So the majority rejected that theory and said that the term navigable has some meaning after all, and indicates at least the authority Congress had in mind in enacting the Clean Water Act, its traditional authority over navigable waters. So isolated non-navigable waters are clearly excluded way back in 2001. Which is sort of the trial run of Sackett in many ways, is a case called Rapanos versus United States. And in this case, the split between the conservatives and the liberals on the court over how to define the scope of the Clean Water Act results in a 4-1-4 split, with no opinion gaining a majority of the justices. 4 conservative justices asserted, in an opinion authored by Justice Scalia, that the waters of the United States includes only relatively permanent bodies of water connected to traditional navigable waters and wetlands that are indistinguishable from such waters. That is, that they're contiguous with and have continuous surface connection with such waters. Very narrow reading of the scope of waters of the United States, and one which presages the court's recent decision last month in Sackett. 4 liberal justices dissented, stating that they would uphold the Corps' regulatory interpretation that it has jurisdiction over all wetlands adjacent to navigable waters and their tributaries. Justice Kennedy, however, and remember I said it was a 4-1-4 decision, Justice Kennedy concurred in the conservative plurality's opinion that the wetlands at issue in Rapanos were not subject to federal jurisdiction. And in his concurrence, announced an entirely separate approach to determining whether adjacent wetlands, in fact, qualify as waters of the United States. And he coined, he framed the test as whether wetlands have a significant nexus to navigable waters. And he's citing the Swank case, which had earlier used that in one sentence to say that it was the significant nexus of wetlands to navigable waters that was the basis for jurisdiction. So that significant nexus test of Justice Kennedy's ends up governing the field of wetlands determinations over the next 17 years. Because there was no majority opinion, his concurring opinion effectively is the opinion with which 4 other justices would agree. The 4 liberal justices would all agree that all of the wetlands that Justice Kennedy found within the Corps' jurisdiction were also within their approach, because their approach was much broader than Justice Kennedy. And so lower courts viewed that split decision as effectively saying that any wetlands that would meet the conservative plurality test, meaning that they were directly adjacent to navigable waters, clearly would qualify, because all the justices would agree on that, and that also any wetlands that met Justice Kennedy's significant nexus test would qualify as waters of the United States. This becomes important because the federal agencies, the Corps of Engineers and EPA, then try to adopt the significant nexus test as at least a significant part of how they define in their regulations the scope of waters of the United States that are subject to federal permits. The Obama administration issued a very broad definition back in 2015, relying in part on the significant nexus test. The Trump administration repealed that rule, replaced it with a very narrow definition, limiting waters of the U.S. to traditional navigable water, tributaries and lakes and adjacent wetlands. And that was then vacated by a court in 2021, replaced by a broader definition, now largely, I think, superseded by the court's decision under the Biden administration in 2023. So this is the framework in which the court acted in taking the Sackett case. The case involved efforts of landowners to build a lake home on lands near Priest Lake in Idaho. The property contained wetlands near a creek that drained into the lake. In preparation for building, they backfilled their property with dirt and rocks starting in 2004. EPA sent them a notice to cease and desist, informing them that that their property contained jurisdictional wetlands, and ordered them to stop and restore the property. They first sued to challenge the Corps' jurisdictional determination. The Corps was the agency that made the jurisdictional determination that these were wetlands that were subject to the Clean Water Act. And that case had to go to the Supreme Court in 2012 because up until then, the lower courts would not allow property owners to challenge a jurisdictional determination until they had applied for and been denied a permit. The Supreme Court said, no, you can challenge such determinations right away under the EPA. And after 7 more years of litigation, the district court entered summary judgment for EPA. Ninth Circuit affirmed in 2021, holding that the Clean Water Act covers adjacent wetlands with a significant nexus to traditional navigable waters, and that the Sackett lot satisfied that standard. The Supreme Court granted review. So what did they do? Remember, the Supreme Court now has a number of new conservative members. Justice Scalia is deceased, but 5 conservative justices essentially endorse Scalia's plurality opinion in Rapanos in 2006. Justice Alito, writing for the conservative majority, opens with a condemnation of the costly and burdensome regulation of wetlands by the Corps and EPA, including saying that the Clean Water Act is a potent weapon with crushing consequences for even inadvertent violations. The majority opinion reasons that waters must refer to bodies of standing or flowing water, like rivers or lakes, consistent with the traditional understanding of navigable waters, and concedes that some wetlands must also be included because of the language I mentioned earlier of Section 404G, but concludes that those wetlands must, quote, qualify as waters of the United States in their own right, by being indistinguishably part of a body of water that itself constitutes waters under the Clean Water Act. Well, as you can see from that, they've effectively read the phrase adjacent wetlands out of the statute, because if they were already waters of the United States in their own right, they did not need to be identified separately. They simply qualified as waters of the United States. The majority then reads the term adjacent as only meaning adjoining, even though the dictionary definitions, as they acknowledge, are broader than that. Adjacent can mean neighboring or nearby. But because they've already concluded that wetlands can qualify as waters only if they are connected to and indistinguishable from navigable waters of the United States, they say wetlands that are separate from traditional navigable waters cannot be considered part of those waters, even if they're located nearby. So their first determination that to be waters, they must be part of another water of the United States, then informs the way they have to twist the term adjacent so that it includes only contiguous or abutting, as opposed to adjoining or as opposed to nearby. The court then concludes that an agency asserting jurisdiction over adjacent wetlands must establish first that the adjacent body of water constitutes waters of the United States, i.e. a relatively permanent body of water connected to traditional interstate navigable waters. And second, that the wetland continuous connection with that water, making it difficult to determine where that water ends and the wetland begins. The Sackett majority rejected EPA's arguments. EPA argued for a broader test for adjacency based on the significant nexus test. The court noted that that test would allow such staggering federal jurisdiction over waters as to impinge on states' primary authority for land use regulation, and declared that Congress would need to have enacted exceedingly clear language to have thus unsettled about federal and state power. The court noted that the vagueness of the significant nexus test raised significant due process concerns for criminal prosecutions under the Clean Water Act, rejected EPA's argument that Congress had acquiesced in prior administrative interpretations of the waters of the United States, and finally flatly rejected EPA's policy arguments regarding the ecological consequences of a narrow definition of adjacency, noting curtly that the Clean Water Act does not define the EPA's jurisdiction based on ecological importance, something that might have surprised the authors of the Clean Water Act. Justice Thomas and Gorsuch filed a concurring opinion, joining in full in the majority opinion, but noting that in their view, the terms navigable water really could only be understood by reference to 19th century precedents involving federal regulation of navigation. And going on to say that that the authority under the Act is solely the authority that Congress has to regulate channels of interstate commerce. So, for example, any effort to regulate things that might affect interstate commerce is not invoked, in his view, under the Clean Water Act. And in fact, he suggests that the only thing that could be regulated by Congress under the Clean Water Act would be pollutants that obstruct navigability. And he concludes by complaining that the court's Commerce Clause decisions since the New Deal depart from the original meaning of the Constitution, and singles out federal environmental laws as particularly dependent on an improperly expansive reading of the commerce power. So we have two justices on the right wing of the court that would even more sharply limit the Clean Water Act and all environmental programs. 4 justices disagreed. They concurred in the judgment, which makes technically the court's decision unanimous that these wetlands, the Sackett's wetlands, are not jurisdictional. Justices Kavanaugh, Kagan, Sotomayor, and Jackson dispute the majority's failure to acknowledge the meaning of the term adjacent, meaning more than adjoining. These 4 justices would hold, and this is the only place they go that is different than the majority, would hold that wetlands separated from other waters by dikes, berms, roads, or dunes qualify as adjacent. No justice attempted to defend the significant nexus test that had been propounded by Justice Kennedy and Rapanos and that had been the governing standard for the last 17 years. All of the justices concurred in holding that the wetlands on the Sackett property do not qualify as wetlands subject to jurisdiction. So what are the implications? Let's turn to what the case now, we have to live with this case. What does it mean? Well, first and most obvious, a loss of significant federal protection for wetlands in the United States. Based on data in the National Hydrography data set maintained by the United States Geological Survey and the National Wetlands Inventory, 51% of National Wetlands Inventory wetlands do not intersect NHD map streams. So they would be excluded because they would have no surface connection under this decision. According to that data, 13% of NWI wetlands intersect with intermittent streams and 0.5% intersect with ephemeral streams. If the courts follow the Sackett majority statement that waters of the United States need relatively permanent flows, then the total of wetlands that may be excluded in the United States rises to 65%. And it's more than that, because these estimates that I was able to find do not address wetlands that do intersect with NHD map streams, but that are separated by berms, dikes, dunes, or roads. And when you think about all the wetlands along the Mississippi River that are separated by levees and dikes, all of those presumably are now excluded from Clean Water Act jurisdiction. And that may be millions of acres of wetlands and very important ecological wetlands. So state laws may provide a crucial backstop for wetlands protection. My colleague Betsy Nicholas will talk about this, but many states do not have state wetlands laws, and the ones that do often limit the scope of their programs to the federal definition of jurisdiction. And states are going to be under a lot of pressure to take on the greater workload left by the Corps vacating the scene for 65% of the nation's wetlands. It's broader than that, though. The Sackett decision's declaration that waters of the U.S. must have relatively permanent flows may end up stripping the great majority of rivers and streams in the nation of federal protection under the Clean Water Act. According to the National Hydrographical data set, only 30% of the streams in the U.S. are perennial. The other 70% are either bent, that's 52%, or ephemeral. Some portion of those, maybe all, are at risk of being excluded from federal jurisdiction by the Sackett Court's view that waters of the U.S. need relatively permanent flows. And it gets much worse in the arid West, where 82% of streams and 87% of stream miles are either intermittent or ephemeral. The court's statements regarding the need for permanent flows could be characterized as dicta because the court's holding focused on whether the particular wetlands was adjacent to a water of the United States and determined that it wasn't because it wasn't physically contiguous to it. But their clear definition in their minds of what constitutes waters of the United States will undoubtedly spark litigation contesting federal regulatory authority over intermittent and ephemeral streams. And what will that mean for the Clean Water Act NPDES program? It remains to be seen. None of the opinions in Sackett address that possibility, but it's interesting that the 2006 Rapanos decision, that the Scalia written plurality opinion in that was largely adopted intact into the Sackett majority opinion. In that, Scalia addressed that issue and dismissed those concerns, noting that the Clean Water Act prohibits the addition of a pollutant to navigable waters, not the direct addition of such a pollutant, and that enforcement actions in lower federal courts have treated intermittent stream channels as point sources that convey pollutants to downstream navigable waters. It remains to be seen how how valid that will be. Let's hope it is. But it certainly will lead to litigation over the applicability of NPDES permit programs. Other implications, I want to credit my friend and colleague Jim McElfish of ELI, who put an article out right after the decision that was very thoughtful, and he noted that the law that the federal permits for wetlands fill are often the only hook for the application of other federal laws, such as the National Environmental Policy Act and the Endangered Species Act, that would help protect environmental values. And by the way, when I say ESA, what I mean is consultation requirements that would apply to federal agencies. The ESA obviously would apply to private landowners in terms of prohibiting take, but the consultation would only occur if there was a federal permit involved. So that's significant. He also points out, I think, very sensibly, that there's a multi-billion-dollar compensatory mitigation industry that's developed in substantial part because of requirements for mitigation and federal permitting. And it's unclear what this decision will do by contracting so sharply the scope of federal permitting for wetlands. And finally, I would just note that, you can't read the majority's opinion, which goes on for pages about the overbreadth that they believe that Corps' application of the statute involves, and the charged language they use to attack that, the evident hostility that the court's new conservative majority feels toward environmental programs may presage future decisions, sharply reining in federal programs under other laws. That's happened once already last year with West Virginia versus EPA, which read the EPA's authority of the Clean Air Act narrowly, and used the same notion of a clear statement in interpreting the scope of the Clean Air Act. Among other things, the requirement for a clear statement does away with any kind of Chevron deference to agency interpretations. And as Justice Kagan noted in her concurring opinion, the clear statement rules that come into play are invoked by the majority of the court when a statute affects private property or land use regulation, or the balance between federal and state power essentially amounts to a thumb on the scale for property owners. Justice Kagan noted, today's pop-up clear statement rule is explicable only as a reflexive response to Congress's enactment of an ambitious scheme of environmental regulation. It is an effort to cabin the anti-pollution actions Congress thought appropriate. The court has thus appointed itself as the national decision maker on environmental policy. I'm going to switch now to Betsy, who will offer some thoughts about state wetlands protections that may serve as a safety net.
I wish I was going to tell you a lot of really good news, but perhaps that isn't, in fact, what we have ahead of us. As Bob said, this is a very disturbing decision and doesn't come out of nowhere. It's been building and generating steam of sort of an anti-environmental sentiment, but we're talking about our waterways, and we're hitting a period of a time where we recognize that the unfettered pollution from things, industry like PFAS, is microplastics, are in our blood and in our brains. So the thought that less regulation, less control, less authority and oversight is the way to go seems exceedingly short-sighted. So let's talk a little bit about the states and how they fit into this big picture with the federal decision, the court's decision, authority with EPA. As Bob talked about, there are sort of two avenues that we look at under the Clean Water Act. Section 402, we're lawyers, we can't help but say the section number sometimes, and 404. 402 has to do with our water pollution discharges and the permitting system that we use to regulate those pollutants. 404 is about wetlands and streams and filling them. So the EPA administers the 402 permits, but most states have become authorized to issue those permits. There are a few exceptions, about 7, I believe, off the top of my head, including DC, because DC is not a state, that are not able to issue their own permits. But notably, those are just on the 402 side. And so that's your sort of point source discharge, your pipe, your sewage overflows, all those sorts of things, your industrial users. But when you're looking to fill wetlands or streams, that's under 404 and the Army Corps of Engineers. Only 2 states have actually taken over those programs and have independent authority to issue those permits. So for all other situations with states, they're going to have involvement of the Army Corps of Engineers, and that authority is going to change under Swank now. Under Sackett. Let's see if I can get this to move forward. It does not seem to be moving. That is peculiar. Oh, there it is. It was just delayed. Okay. So there is a little bit of good news here that some states have permitting programs themselves. We live in an area where quite a few of them do. They issue things, for example, like wetlands permits or other, crossing streams, etc. But that doesn't necessarily mean that they have their own definition for what constitutes waters of that state. A lot of them, in fact, use the federal definition despite having their own independent permitting program. So 26 states and DC have these permitting programs. But again, if they're not then defining waters of that state separately from the federal definition and only rely on that definition, the federal, it just changed like that with this Sackett decision. So that narrowing the huge loss of authority over wetlands and waterways that Bob was discussing has just gone into effect across the country in roughly half of our states without any other action being taken. So, like I said, there is a little bit of good news on the other end of this, but the aspect of how we define the waters of the state for each of these states is really important. And they can only go to how they define it under state law. You can't then bring down federal authority under the Clean Water Act, which is primarily what organizations like Potomac Riverkeeper Network use to enforce the law, is that federal authority coming down at the state level. But again, states have some independent authority and some have taken this action to go further and define these waterways more expansively than what is federally required. But even if you have this sort of ideal situation with the state where you have an independent permitting program and a state definition of waters of the state that is broader than that of just deferring to the federal, that may not mean all that much. Most of these programs, in fact, virtually all of them, suffer through a variety of mechanisms. One of the most significant to groups like ours is they lack a citizen suit provision or an opportunity for anyone other than the government to take an enforcement action against a polluter or violator of that law. But environmental agencies across the country are suffering for lack of funding, historic lacks of funding in them, lack of expertise and the personnel necessary to take on this huge gap of understanding these wetlands and waterways that might now just be covered under state law and not under federal law. So if we're going to have some hope of the states being a little bit of a backfill mechanism for us here, where these tools exist, we're still going to help them get up to speed to take on this great additional burden. So this is my sad Bren face. I was hoping I could get the happy joy in here, but unfortunately, all we've got is little tiny silver linings out there. So there is some good news, right? We're not completely flooded and the house is on fire in some states. And just speaking specifically to this region, Maryland and Virginia both have broad definitions and independent permitting programs. So here we go. Here's an opportunity. What can we do with this? Can we use this mechanism to get better protections? I mean, they're set up for it, right? They've got the authority, they have the definitions, but they also have unbelievable pressure on them right now. The states are now the only ones protecting so many of these waterways from just becoming developed and filled with any kind of materials. I mean, just paving over basically streams and wetlands. And I think just judging from the sort of attendee list here, I think most of you kind of get why wetlands are so important. It's not just from the sort of environmental, ecological perspective, but in times of increased precipitation, which we're suffering, no matter what you think are the causes of climate change, right? That we have more flooding, more extreme weather events. Well, if you spill, 20 gallons of water on the floor and the floor is covered with sponges versus none of them are there, that's kind of what we're talking about here. Those wetlands, they take floodwaters in, they hold them so that they can move out more slowly. They are the most effective tool to combating the extreme storm events from climate change. Hurricane Katrina was the perfect example of this. And we know how well that worked out. So we're facing a pretty monumental task here at trying to figure out what to do to protect our waters and ensure that we're not just damning future generations to uncontrolled flooding and contamination. All right, so let's try and think about some positive pieces here. Maryland already has good, strong laws. We have an administration that has shown already an interest in protecting waterways and acknowledging the risks of climate change, but we can still strengthen it. So the Wetlands and Waterways permitting program under state law versus the National Pollutant Discharge Elimination System is treating these ephemeral waters, the ones that don't run all the time, differently. So we could shore that up and make sure that those connections are strong. The thing that we need probably more than anything else is we're going to need more staff. So more funding for the Maryland Department of the Environment and particularly the Wetlands and Waterways program to ensure that there are people who can go out and analyze these streams, who can spend the time when they get the application in for fill to go and verify that no, these are protected streams. They can't do that, at least without a permit and certain conditions. And then enforcement. Maryland does not allow third parties to enforce under state law. So as we've seen, actually, Potomac Riverkeeper's got a number of actions right now under the traditional method where the state wasn't able to, for lack of funding or lack of political authority or any other variety of reasons, to enforce the law on their own. So we have brought actions where often the Maryland Attorney General or joins in with us. For example, the Metcom case where people in Virginia were ate contaminated oysters and ended up in the hospital. So that enforcement mechanism is really important when the state isn't able to do it. And so strengthening that in Maryland state law, allowing third-party enforcement of the same laws would be tremendously helpful to protecting Maryland's waterways. In Virginia, we've got a slightly different story that we have already heard, basically, day the decision came out, that there are a lot of parties working to roll back Virginia's more comprehensive program than the federal. They just want to go to the federal level from the Sackett decision, meaning that we're going to lose more than 50% of the wetlands and waterways from coverage. So that is something we have to defend against really strongly. It's going to be extremely important in the upcoming 2024 Virginia legislative session. Again, we're going to need funding for personnel to go out there and look, do these hydrology evaluations and figure out what streams need to be protected. We need to educate the lawmakers in Virginia about the risks. Seafood industries, I mean, there are so many recreation, so many things that are going to be adversely impacted if we allow the destruction of our streams and wetlands. And then we need to monitor what's happening to see if there is any level of rollback, the damage that it's causing down the economic lines based on the protection of ecology, wetlands, water, and looking at what it does to public health to lose all of these resources. And we are working on these issues right now and preparing. And for those of you wondering, what can you do? You can help with all of this, wherever you fit in on this, in terms of educating, sharing information, pushing back on any rollbacks, fighting to strengthen these protections for you and your family in the future. And we can't do it alone. So this is an opportunity to push and fight back. And the one thing I'd say in addition to that is vote. So Bob and I now want to just kind of talk through this a little bit for you, and we're going to be happy to answer questions as well. So Bob, if you had a magic wand and could change something in state law to help us counteract this terrible decision, what would you do?
Well, what you would want to do would be to particularly prioritize the states that have no state wetlands programs, because that's where there's going to be no safety net at all. I think, you know, we're pretty, we have a luxury in London, Virginia, of having pretty good state programs. We have to fight to defend them. Certainly in Virginia, we'll have to fight to defend them. But there are many states across the country that don't have a wetlands program, where wetlands are now no longer subject to any regulation. So that would be, you know, that would be what I'd go for. We do have some questions in the chat as well.
Yep.
I think I would offer an observation, which is just that, you know, this is a story arc which is sad in one real clear way, and that is that we had a Congress in 1972 that was very pro-environmental. We haven't seen a Congress that pro-environmental since the 1970s, and we certainly don't have one now. And yet they didn't define with enough clarity the scope of the authority that they were conveying to EPA. EPA and the Corps of Engineers interpreted their authority as in a manner that would best serve the purposes of the act, and that would provide the best holistic kind of approach to maintaining clean water and protecting the waters of the United States. And now they're reined in by a court, a conservative court that has read the act very rigidly. And the problem is we can't really turn to Congress for relief, because I think at this point environmental issues are so polarized politically that it would be difficult to expect that we get bipartisan support for a bill that would dramatically expand or return the jurisdiction of the Clean Water Act. So it's kind of a sad story, and and the saddest part of it all, for me at least, is that what happened to the sense that protecting the environment was something that all Americans cared about, and that sense that it really inspired the Act and other major federal laws in the 1970s. And how do we manage to make environmental protection less partisan and more something that all Americans appreciate? That's a tough challenge. If I had a magic wand, that's what I would do.
Thanks, Bob. Serena forwarded a couple of messages or a couple of questions that had come in with registration to us. And one of them was, what about municipalities and places like DC? So DC is not delegated authority from EPA to issue their own permitting program, but they do for the Clean Water Act, but they do have their own parallel program. And I think what we're going to see in a lot of those places is that we aren't going to get the same level of protections. So what the states are able to do, or places, municipalities like DC, are going to be dependent in large part on the federal, but if not the federal, then the state. So they're only going to be getting protection in places where there is that independent layer. For DC, EPA issues their permits under the Clean Water Act, and then the Army Corps of Engineers for any wetlands, waterways fill permits for 404. So they're going to be using the federal definitions for those.
There's a question in the chat about whether the fact that since a lot of developments take place without permits, doesn't this leave developers more exposed to liability, developers and polluters, for being sued directly for environmental harm without the buffer of a permit? Well, you know, the problem is that the contraction of federal regulatory authority also means that it's not a violation of the Clean Water Act to discharge into a wetland anymore. And so and of course, the absence of citizen suit provisions in state laws means that it's going to be very difficult to challenge someone who is just flat out dumping fill into a wetland, even though we think we could demonstrate that it is adjacent to under the terms of the court's opinion. Of course, EPA and the Corps will have enforcement authority if it in fact meets the standards of the court's restrictive opinion. But in terms of demonstrating harm to wetlands that may be protected under state law, it's going to be very difficult because of the lack of a citizen suit provision. So, you know, it's hard for me to see that the contraction in regulatory authority is going to end up having a silver lining. We're going to have to work harder, I think, to try to keep the river clean.
Yeah, and I think that's that question was also maybe hinting at tort lawsuits, but I don't think that there's any reason that those would become more viable than they are right now. So sort of a nuisance or harm type lawsuit, I don't see anything that would help us from this contraction of federal.
Yeah, I mean, the problem with traditional tort remedies, I mean, that's the reason why Congress enacted the Clean Water Act to begin with, was that states had often relied on common law approaches to regulate pollutants that affected their neighbors and neighboring properties. But you can fill a backyard wetland, and it's very hard to show that you've harmed somebody else's interests. You've harmed everybody's interests. These are common goods of environmental quality and of the ecosystem. So you need to have a pretty broad-sided regulatory approach to try to protect things that matter to all Americans and that may not matter to particular property owners that are being harmed.
And I see thanks, Bob. I see a question about West Virginia. West Virginia is not one of those states that has its own independent permitting program and broader definition of waters of the state. So West Virginia is going to be one of those that immediately goes to this new default position under Sackett. So we're going to have to really look at what we can do to protect our waterways there. I think in West Virginia, as an old coal mining state, that while it may not be as much related to fill of wetlands, I think that those stream conveyances and the pollution coming out of those sources are going to be a huge area of concern. Acid mine drainage, coal, contaminated runoff, things like that. I think we got a few more in here. So key questions to ask Virginia legislature this year, I think, about commitments to protecting communities from harm, from damage to upstream. I mean, whether they think that they should continue the commitment that Virginia has made for more than 40 years to have its own definition, a stronger definition for the state, because they recognize the importance of protecting the waterways. Virginia also has a policy of no net loss of wetlands. So it's going to be, what do you do with that, right? It's not like you can bring a lawsuit necessarily on that basis, but it is a statement of intent. And I think that we need to hold all of our lawmakers and regulators accountable for that. You made that commitment recognizing the importance to the state of preserving wetlands. So I think we need to push and fight on that and find out where they stand. Bob, do you want to tackle Lois's question?
Well, Lois suggests that that we should be starting to collect horror stories about flooding of property and that sort of thing, and I think that is part of the public education campaign. And frankly, you know, so in some ways this should be a wake-up call to us. We've depended on the federal government and the leadership of agencies that are well-intentioned, like EPA and the Corps of Engineers, and we have not built the same recognition of the importance of protecting wetlands at the state level. We've seen already what can happen with the federal government when you've got an adverse administration come in. The Trump rule, which was briefly in effect, was almost as bad as a Sackett opinion, but not quite, because among other things, it did allow coverage over wetlands that were separated only by berms or dikes or roads. So it would have covered the Mississippi wetlands. But still, you see what happens at the federal government level. And so all of us, I think, can take a lesson from this, that we need to be building playing on our home courts. You know, we need to be our states themselves to pay attention to these issues and to build stronger programs. I also see a question about groundwater and how wetlands are so important for recharging groundwater. The Clean Water Act typically doesn't regulate groundwater. The Federal Safe Drinking Water Act does protect groundwater that are in wellheads. So if someone were depositing pollutants in a way that would contaminate groundwater that was part of a wellhead for a community where they draw their drinking water, there may be a regulatory handle there.
Do you want to hit Lisa's question about waterways generally?
Well, I do think that this is the question. I mean, yeah. You know, God forbid that more of the justices should start to buy into Justice Thomas and Justice Gorsuch. He now has an acolyte view of the limited role of the federal government in protecting the environment under the Commerce Clause. But yeah, there's a real issue here about how we protect our rivers and streams. And it may be that the education we do with state agencies and with state legislators has to focus as much on that as on wetlands themselves. Most people will probably view this case as only being about wetlands, but it does, in fact, I think, leave a lot of questions about whether the Clean Water Act can continue to protect most of the nation's rivers and streams.
Yeah, and just sort of a practical piece on that. Waterways do what they want. There's lots of them that start up above ground, go underground, come back up. The Potomac River is in Virginia, Maryland, West Virginia, Pennsylvania, and DC. So all of those laws are going to apply differently to the same water body and watershed. It's going to be tremendously complicated and problematic for us going forward of how do we protect these, particularly with the headwaters of this huge stream that most of us depend on for our drinking water being in West Virginia with the least protections.
And I will add that, you know, that this case is going to be a fountainhead for litigation by development interests, because it is really not clear what constitutes a water with relatively permanent flows. It's really, I think, clear that ephemeral streams and dry creek beds are not going to qualify at all. But they were really not included by the agencies anyway. But the real question is, you know, things like seasonal rivers that flow 290 days a year. In the Rapanos decision that presaged Sackett, you know, Scalia addressed that and said, yeah, we think it would include seasonal rivers if it has that much flow. The Sackett decision doesn't say that. The Sackett decision recognizes only that there may be instances where there are low flows because of dry spells or because of low tide. So it's a big question, I think, what the scope of jurisdiction actually is, and it's going to get fought out in the lower courts. And we may have to be weighing in with amicus briefs, trying to argue as strongly as we can that that particular waters do have relatively permanent flows.
All right, I see we got 2 minutes left, so I don't know that we can take any questions directly. But if we didn't get to your question, feel free to send it to us later. We can follow up. Want to thank everyone for attending. I want to thank Serena for pulling us together and keeping us on task. And we need your help more than ever to push this and change it and make sure that we get to dictate what happens to our waterways.
I do want to give a shout out to Jeff Brown, who put in the chat the fact that many conservatives also value clean water protections, and that they may not view it as a partisan issue. And likewise, many conservatives value wildlife, and so wetlands values to all of us. You know, I think we have to educate the public and try to reach as broadly as we can and not rule anybody out. You know, let's embrace anyone that will come to support water protection.
Yeah, water is not a partisan issue. We all need it equally.
Well, thank you, everybody.
Keep it on. Thank you, everyone. We will follow up with the recording from this session and all of the resources that we mentioned. I'm going to stop the recording now.